As many of you know, the international investment law has come under fire in recent decades, predominantly because it is designed to serve the interest of multinationals and private actors to the detriment of other, let's say, social justice-oriented goals such as environmental protection or the eradication of poverty. And this fall at the Amsterdam Law Clinic, Amsterdam European Law Clinic, we've worked along SOMO, and you're going to hear about this in a bit. We conducted a research that essentially showed that in certain respects, foreign investors have more rights under international investment treaties than under Dutch law and EU law. So today we convened this panel to reflect and discuss on how international investment law distributes wealth and power, how it shapes the global economy, and what are its future directions given the numerous proposals, reform proposals that are on the table. And many of you have recognized, I'm sure, that the title of this panel roundtable echoes the article written by Professor Sonaraja in 2006. And we wanted also, similarly to what he does in his article, reflect on whether the law for the protection of foreign investments that he calls the law for greed can foster social justice and environmental justice. So this is what we're going to do today. I'm going to just briefly talk about the structure of the panel and some rules of engagement. So first, we're going to hear from Bart-Jaap Verbeek, who is co-hosting this panel from SOMO, who's going to tell us a little bit about the work that SOMO is doing. Then our wonderful master students will present their memo and the key findings in that memo. Then we're going to move on to the first panel, and I will introduce speakers later who will share some thoughts, some reactions, some quick reactions to some of the key findings in this memo. We will then move on to the second part, and we will discuss future directions. Now, a couple of rules of engagement. So first, we are very much interested and focused on critical engagements with international investment law, because we felt that even though there are many critiques of international investment law today, they're still very much marginal in the scholarship. But of course, this is an open discussion. It is designed as an open discussion. And so we welcome the critiques to the critique. The second point that I wanted to mention is that there will be time for Q&A and engagement with our fabulous panelists. Please use the chat function. You can use it throughout the panel. There will be a possibility to ask your question live. And if you do so, please be straightforward and concise and keep your question under a minute. Lastly, I want to thank Alicia and Sophie for their help in organizing this panel. And now, Bart-Jaap, your turn.
Yeah, thank you very much, Ivana. And also from my side, a very warm welcome to all the speakers and participants. And many thanks to the Amsterdam Center for European Law and Governance and the Amsterdam Law Clinics for organizing this event. I work as a researcher on trade and investment policy at the Center for Research on Multinational Corporations, or SOMO in Dutch. We are an independent nonprofit knowledge center investigating corporations and the impact of their activities on the people and the environment. I want to make a little disclaimer that I am not a lawyer. My background is in political science and political economy, but obviously politics and law are closely connected to each other. We at SOMO are very grateful for the work done by the Amsterdam European Law Clinic, as it addresses some of the important questions that we've been having. The starting point for us has been really a very simple and basic question. Do foreign investors have greater rights in the international investment law as compared to domestic legal systems? How do these substantive and procedural rights and types of remedies available to foreign investors compare to those in domestic and EU law? Now, these questions, they may seem very obvious, but they are important to address to not only better understand what makes international investment law so unique and controversial as compared to other legal systems and avenues, but also to reflect on some of these systems and assumptions and intended purposes. We have been hearing a lot that investment treaties do not increase the potential risk of liability for states with well-developed legal systems because they supposedly offer similar rights as domestic law, but they merely establish a minimum level of protection for investors abroad, similar to what they would enjoy in domestic law. And as the memo clearly shows, and I'm sure we'll hear more about it in a minute, the first assertion does not seem to be accurate. So foreign investors do indeed enjoy greater substantive and procedural rights in investment law as compared to domestic law. And as regards to the second argument, if that is the goal of investment treaties, then there is much to learn from approaches taken by domestic courts in determining state liability and safeguarding the regulatory space of governments, which also highlights the need for better coherence between the domestic and international level. So the findings of the memo raise some very important policy issues that warrant more attention, including on the issue of remedies and the relationship between primary and secondary remedies, and the ways in which domestic courts establish a fair balance between private and public interests as compared to investment tribunals. Now, some governments have tried to confirm that foreign investors do not or should not have greater rights, as shown, for example, in the joint interpretative instrument of the EU-Canada CETA agreement, or in various legislative documents and public statements in the European Parliament and US Congress in the context of the TTIP negotiations years ago. There is much more to talk about. I'll leave it here for now, and I'm looking forward to the discussion. Thank you. Back to you, Ivana.
Thank you, Bart-Jaap. Now we're gonna hear from our master students, Maria Bilwin, Florian Huber, and Jesse Peters, who have done amazing research on this memo, and they will summarize their findings. The floor is yours.
Thank you. I'm just going to share my screen, so please wait a second. I hope you can see it now. Yes, so thank you, Ivana, for your introduction. In our research, we analyzed both substantive and procedural elements of the investment protection under the ECT and CETA, and we have discussed them in comparison to EU non-contractual liability and Dutch and civil administrative law. We located 4 major areas where foreign investors enjoy greater rights under the ECT and CETA, which you can see now on the screen. And these are structure of arbitration proceedings and under the ECT and CETA, fostering an endure and cash-in attitude for foreign investors, margin of appreciation for administrators and legislators, and higher amounts of compensations under the ECT and CETA regimes. In terms of structure, there are 2 main issues which are relevant to the discussion: transparency and the financial incentives. Firstly, in terms of transparency, the confidential nature of proceedings under the ECT prevents access to details of these proceedings, while in case of Dutch and EU law, more stringent transparency requirements are applicable and there is way more scrutiny. Hearings and reasons for judgments are mostly public, and they are not public only in very limited circumstances which need to be justified. Further, in terms of the financial incentives, according to the ICSID convention, arbitrators are appointed by the parties and they have indeed financial incentive to rule in favor of investors in order to be appointed again. There is this incentive to be appointed in more cases and not to discourage parties from bringing their claims. Alternatively, under Dutch or EU law, judges are impartial and independent, and they are not appointed by any of the parties. The parties have no influence over that. The judges also have no financial incentive to rule in favor of the investors, since their remuneration is independent of the number of cases heard. And now my colleague Florian will discuss further points. Thank you.
Yeah, so not colleague Florian, but colleague
Oh,
Tessa.
I'm so sorry.
Don't worry. So our second argument is that investment treaties like the ECT and CETA foster an endure and cash-in attitude, while Dutch and EU law do not. Investors can directly claim monetary compensation, including expected profits, without challenging a public measure that hurts their interests first. While in Dutch law, civil damages can only be awarded after an administrative challenge to the measure. Investors thus have to make an extra effort to get compensation, and if the measure is repealed in an administrative procedure, then they can only make profits by taking actual economic risks instead of offloading them to the state that takes public measures. In EU law, chances of receiving substantial compensation, if any at all, are so slim that one cannot speak of cashing in. Besides the two procedural features that we have highlighted so far, the substantive review of claims by investors in ISDS proceedings across the board is considerably less protective of the discretionary space of legislators and administrators than Dutch or EU law are. This benefits investors and potentially facilitates regulatory chill. The memo highlights several areas of comparison, but the protection of legitimate expectations provides an illustrative example. Investment treaties have interpreted this open-ended term broadly, including in cases of evolving climate regulations. But in contrast, Dutch law applies a restrictive concept of legitimate expectations, and it is important to note that Dutch courts have been at the forefront of climate litigation, including in the recent SGEL ruling. Under EU law, violations of legitimate expectations have to be sufficiently serious, which is an additional hurdle that in recent cases has been proven to be extremely difficult to meet. Now my colleague Florian will continue with our final conclusions.
With all of that said, the playing field for foreign and domestic investors does not look so level anymore, as some have claimed. Certainly, the chance to get higher compensation is crucial for investors. And that is what they do under ECT and presumably will under CETA. The infamous sums in UCOS v. Russia are well known. Calculation standards are used to provide for full compensation. Discounted cash flow is just one trigger word here. Investors really try to push the limits with mega claims. Compared to that, mitigating factors are applied under Dutch law to make sure the awards here do not reach extraordinary proportions. EU law also delivers rather insignificant compensations. So wrapping it up in the swiftest manner, we would like to thank everyone today, and we're really excited to hear from the fantastic panel.
Thank you so much. Let's move on to our first panel then. Our first speaker is Andrea Leidner. Andra is Assistant Professor of International Law at the Amsterdam Center for International Law at UvA, and she's also a member of the Sustainable Global Economic Law Project. Then we will hear from Nicolas Perrone. Nicolas is Associate Professor of International Law at Universidad Andrés Bello in Chile. And he just published a book entitled Investment Treaties and the Legal Imagination, How Foreign Investors Play by Their Own Rules. And finally, we will hear from Lawrence Ankersmit, who is Assistant Professor of Law at AELC, also member of the SGEL project and Director of the Amsterdam European Law Clinic. Thank you all for accepting our invitation. And Andrea, please go ahead.
Thank you very much, Ivana. Thank you for the invitation, and thank you very much to the students for this really insightful and very well structured and researched document. I think that I will follow on from what Bart-Jaap said at the beginning. It sounds like a very banal question, right? What is the relationship between the rights under domestic law and under international law? But this is really where everything is buried. So I think you put your finger exactly on the right spot. And so in order to enable a conversation, I'm going to keep it very short. What I would like to do in these maybe 5 minutes is to tie these questions of what does it matter or why does it matter where the authority is allocated, if on the international level or the national level, how this is a negotiation that goes back at least another 120 years, if not longer, and how the stakes of this conversation have always been high and how this was discussed in many forms and shapes. And I think that it's important to remember that, because that shows us a little bit the direction that international investment law is pushing, if we remember what it was pushing back against when it came into being. So let me say that really the question of should the national state, the national legislator and the judiciary have the authority to decide over the fate of foreign property investments, or should it be an international legal standard, is really one of the key questions that comes back here. And this was discussed very, very with much tensions at the beginning of the 21st century. And I just want to recall 3 things in a sense that pushed on this. The first one is that at the beginning of the 20th century, we had a democratization of the state in many ways. So the right to vote was expanded. Many new interest groups in a way found their interests to be representable in law through the legislator and within the judiciary. So there was a democratic pressure onto the state and on this level of decision making. At the same time, socialist transformations and large-scale land reforms, if you think of the Soviet Union, if you think of Mexico, if you think of Eastern European countries, were happening on the level of national legislation and national lawmaking. And then finally, of course, also in the first half of the century, but then moving all the way into the second, decolonization and so-called newly independent states now being in the seat of the legislator and making legislation. And so in a sense, what we see here is that with this pressure on the authority over precisely these foreign investments, so companies that held land, that held infrastructure projects, that held mining installations, they were now, so to speak, of the mercy of a new kind of state, a more democratic state, a more socialist state, you call it. But basically the idea was really, I think, that there is a threat to the accumulated wealth that companies were able to amass through the rights that they were given in contracts that were considered to be part of domestic law and that were subject to domestic courts. And in a response to that threat, we see what Professor Sonaraja has coined the internationalization of contracts. So in a slow process that we might maybe want to go into in more detail later, but in a complicated and multifaceted process, what happened was that from a regime in which concession agreements were subject to national jurisdictions, we now have an international legal regime that holds the authority over these contracts, and these contracts ultimately secure the question of how the gains of these undertakings are distributed. And so I think that really we have been discussing that and I mean by we is people interested in that, and I just transpose myself historically a couple of 100 years back, and I would still be interested in this. So how do we distribute these gains? And international investment law as it stands is really geared toward enhancing the accumulation of wealth in private hands and by private companies. So I would leave it at that as a provocation.
Amazing. Thank you so much, Andrea. Nicolas?
Yes, Ivana, thank you very much. I'm super delighted to be here, and thanks everybody for their thoughts. Just if you give me a second. So what I would like to do today is to focus on one question that has, I think, attracted the attention of many investment lawyers, which is if it's possible, whether it's possible to strike a balance between foreign investor rights and states' right to regulate, or the public and the private. And in a way, that has been the million-dollar question. I mean, it's whether investors have more rights, but also whether we can reach a balance all the countries that sign the treaties are happy with. And I think that this debate is informed by an assumption, and the assumption that there is a formula somewhere that can solve the problem. And investment lawyers have been looking for this formula, sometimes looking into US law. So in the US, the US Supreme Court has, used several times the formula of balancing. In European and German law, for instance, is the notion of proportionality, and it is as a way to try to strike this balance. And then there's public and law analogies, comparative law, or in this search trying to find this balance. More recently, some treaties they try to incorporate WTO language, like GATT Article 20, or even they try to insert some ISDS precedents. So the Metanex formula has made it into some treaties as well. So all this is in this kind of, in this project to try to reach balance. I know that Rob House is going to talk later about this new treaty, so he will probably focus on that later on. But what I want to say is that this search for this appropriate formula, the right formula, and whether we are looking for this formula in domestic law or international law, will inevitably fail. And the reason is that there is no magic formula, unfortunately. There is no formula that we can tell arbitrators to follow in every single case that will lead to a decision that we are happy with just because they are following that formula. And this is something there is consensus in comparative law. There is consensus that the state's right to regulate, the notion of police powers, for instance, is an indeterminate concept. And the same happens with property or contracts or any other kind of what foreign investor rights would be like hybrid rights. And this is because what matters is not so much the text, but actually what is the background of the interpretation of the adjudicator. So Frank Michelman in the 1990s, a US scholar, he pointed to the political theory that is behind the interpretation. That's kind of what is really calling the shots, if you want to. More recently, David Kennedy, focusing more on international law, he says what really matters are the background conceptions about economics, public and private authority of the adjudicator. That would be in our case, investment arbitrators. Greg Alexander, who is a US property and constitutional scholar, he conducted a comparative study of US, Canadian, German, and South African law. And his conclusion is that regardless of whether judges use the formula balancing as they do, for instance, the US Supreme Court does, or the formula proportionality as judges would do in Germany or in the European Union, again, the question is the purpose that they assign to property, the purpose that they assign to state, the operation of the state. So going back to what Andrea was saying, how is the state operating? What is the state trying to serve? Is it trying to serve, the community? Is it trying to serve the maximization of wealth? Is it trying to serve just the private interest? So what I want to say here is that there are two levels of discussion. What is the text of the treaties? And then we can, think about how to improve the text in one way or the other. But it's the second one. There's a second one that we could call is that relates to knowledge about law, that relates to the legal consciousness, that relates to a legal imagination. And that is what really guiding the interpretation. And I'm afraid that that cannot be easily reflected in the text. You cannot incorporate legal culture. You cannot incorporate history of previous decisions all in legal text. And I'm skeptical that you can do that with the creation of a new court as well. A new court would not bring with it new legal culture, would not bring with a new history. Of course, you can try. And I think a good case study here is the Italian constitution. If you look at Article 42 of the Italian constitution, it included the notion of social function. In other countries, that has been represented as social obligation clause. And Stefano Rodotà, a very famous Italian lawyer and constitutional and property lawyer as well, he said he showed in his book Property is a Terrible Right that you can interpret that social clause as either a commitment to economic liberalism or actually a commitment to the increasing importance of the state's economic intervention in the economy and labor rights. And if you go through his book, which is fantastic, you'll find that again, he says the question is not so much the text of the Constitution, but the history behind that, how that evolved, the legal culture surrounding the Italian, not only Constitution, but the Italian legal system. And Rodotà says this is very important, not only because of the particular disputes that get to say, in this case of the Italian Constitutional Court, but what is at stake when we're talking about property disputes. He says that's why property is a terrible right, because of what is at stake. It's very relevant. So there are more things at stake than the private and public law tension here. One is that foreign investor rights don't exist in the vacuum. There are also other rights, non-third party rights, the rights of local communities. And I know that Alessandra will touch on this point later, so I just leave it there. But there are other tensions too. One is the tension between the global and the local, global standards and standards that are developed nationally or even locally. Investment tribunals often tend to prefer global standards over local standards. And this is something that has attracted less attention. Most of the focus has been put on the private-public tension. And in addition to that, and Andrea just mentioned that, and the importance of decolonization in the origin and the developed evolution of investment law, there is a north-south tension, something that again has attracted much less attention recently. So I'll leave it here and look forward to the conversation. Thank you very much.
Thank you, Nicolas. Just a reminder, in a couple of minutes, we will collect questions from the audience. So please remember to use the chat function or raise your hand to ask your questions live, provided that you keep it under 1 minute. Okay, so Lawrence, your turn.
Thank you, Ivana. Well, first of all, congratulations to the students for producing such an excellent and very readable report. I think it's tremendously helpful information for, I think, SOMO, but for all of us really to get this discussion started that we're also having now today. And I wanted to say a few words on, let's say, the standards that are used in EU law that's also developed in the report. And although I very much agree with what Nicolas just put forward, that it's not really about the standards, but more about, let's say, the context and the culture that informs those standards, I think it's still might be nice just to pinpoint some things that might explain this huge difference in, let's say, success rate between a damages claim, a successful damages claim under EU law, than that of under international investment law. So the students highlight in their study that under EU law, only 23 out of 530 cases have resulted in a successful damages claim. So that's a success rate of 4.3%. And if you compare that to international investment law, there we have, at least from the cases that we know, a success rate of 20% for indirect expropriation claims related to indirect expropriation, and 36% on fair and equitable treatment. So that's for the fair and equitable treatment standard, that's almost 10 times as high of a success rate as under successful claims for damages under EU law. Now, what the students highlight also in their report is that there is this huge deference when it comes to the discretion that the EU institutions have when they when they enact public interest measures. So that's something that's a bit of a subjective standard. So that's definitely something that is probably more prone to culture, but like it's still good to highlight that that there is within the ECJ's case law a very big awareness that damages claims cannot have a negative effect on the exercise of the legislative function. So that means that it doesn't matter whether a rule is breached, but the EU institutions must have manifestly and gravely disregarded the limits of the exercise of their powers. They must have really fundamentally breach the rule before you can make a claim for damages. Now, a second, I think, important explanation for why EU law is, let's say, much more deferential, or like why claims are much less successful, is that under EU law, you have this Schutznorm principle, which means that only a sufficiently serious breach of a rule of law, which is intended to confer rights on individuals, can result in a successful damages claim. So, in other words, if there's, for instance, if a government completely messes up environmental procedures or environmental rules, that does not necessarily, that doesn't allow you to claim damages under EU law, or if the EU institutions do so, because those breaches of law are not intended to confer rights on individuals, but are intended to protect the environment. So that's something that you won't really see within in international investment law, because there you already have like certain rather broad rights, for instance, when it comes to the fair and equitable treatment standard. And the last point that I think that I would like to highlight, just to add to the report but made by the students, is that even though, as the students say, under EU law, a damages claim is an independent remedy, which means that you can start it regardless of an annulment claim, these two claims are still very much related. And there was a recent case in which that very much came to the forefront, and that's the People's Climate case, where the Court of Justice repeated that even though a damages claim is an autonomous form of action, you cannot use a damages claim to basically seek annulment of a particular measure, which also, in terms of access to justice, really makes that damages claim much less likely to succeed, because also of the incredible difficulties that private litigants have in seeking an action for annulment under EU law. So yeah, that made me think, well, is this very, let's say, differential approach by the Court of Justice necessarily better than that of the approach that is taken under international investment law? In terms of standards, maybe not so, but I would think that that what is very important for me is that you don't have separate regimes. So I'm very much in favor of what, for instance, South Africa has done when it comes to protecting foreign investors, and that's simply to regulate or the protection of foreign investment under its own constitutional system. So to not have this separate regime, but simply an integrated regime that is governed by domestic courts. And I think that should be the focal point also, because that allows, let's say, the South African legislator to be in the driving seat when it comes to deciding what exactly should be the balance when it comes to regulation in the private interest and the protection of foreign investors. I'll leave it at that, Ivana. So the word is back to you.